A very good evening to all of you. On behalf of the Mediation Society, I warmly welcome you to the first session of our two-part conversation, Why Every Lawyer Should Learn Mediation.
Very good evening to all of you. On behalf of the Mediation Society,
this is Advocate Amina Rafiq, and I will be the chair for today's session. Mediation is no longer an alternative at the margins of our justice system. It is becoming an integral part of the legal practice, which is supported by courts, embraced by clients, and strengthened by law. Yet, we see many lawyers continue to see mediation as something only mediators need to understand. Today's conversation invites us to think differently. We will explore why mediation is an essential skill for every lawyer, not just those who wish to become mediators. We are delighted to have a wonderful panel with us this evening. It is my pleasure to introduce our lead speaker, Advocate Rajesh C. Muttat. Advocate Rajesh, the president of the Mediation Society, prefers to describe himself as a mediation activist. Through his work, he has consistently encouraged lawyers to see mediation not merely as a process, but as a professional mindset that enriches legal practice. Welcome, Advocate Rajesh. Advocate John Nelimala Sarai is an advocate with 28 years of experience, including 15 years with various Government of India public sector enterprises, such as the Airport Authority of India, Bharat Electronic Limited, Kochi Metro Rail Limited, etc. She's also a university rank holder from the Kerala University in LLB. Welcome, Advocate John Nelimala Sarai.
Thank you.
Advocate Aditya Tejas Krishnan, our next speaker, who has been practicing before the High Court of Kerala since 2016, specializing in service law and appearing before various tribunals and the High Court of Kerala. He is also guest lecturer in law, teaching several subjects, including alternative dispute resolution. He is also a member of the Professional Development Division of the Mediation Society. Welcome, Advocate Aditya Tejas.
Thank you, Amina.
Advocate Joel Kenneth Johnson, an advocate, mediator, arbitrator, and a registered trademark attorney practicing before the Supreme Court of India and various high courts. He is a Supreme Court and MCPC certified mediator who leads the knowledge and communication vertical at the Mediation Society. He is passionate about making dispute resolution more accessible. Welcome, Advocate Joel Kenneth Johnson.
Thank you.
Our final speaker, Ms. Munira Ali, a final year BCom LLB honors student at Bharatamada School of Legal Studies, is a member of the Professional Development Division of the Mediation Society. She is deeply interested in mediation, negotiation, and collaborative dispute resolution. Welcome, Munira Ali.
Thank you.
Once again, I welcome all our speakers. And now, Advocate Rajesh C. Muttat, the lead speaker, will lead us, and other panelists are free to intervene as he speaks to share your thoughts. The floor is yours, Advocate Rajesh C. Muttat.
Thank you, Amina. Thank you. A very good evening to all of you. We will keep this very conversational, and that's the idea anyway. Mediation Conversations is about talking about mediation, coming together on an evening, hopefully every month, and talking about developments in mediation or things which are important in mediation. Tuesday may not be the best of the days, but yet we have to find a day, so we found this Tuesday. Now, as I said, this would be more conversational. It won't be a discourse on why every lawyer should learn mediation. We will be recording this session, and that's the reason why only 6 of us are appearing on the screen. And you may communicate with us through the chat. You may not be able to unmute yourself, which is deliberate. But for recording purposes, we are doing it. So please put your questions in the chat, your comments in the chat. We will pick it up and try to answer if we know the answer, by the way. Now, we are going to talk about, of course, the topic is why every lawyer should learn mediation. In fact, there is a mistake in the poster which we made. We put a question mark to it. Actually, it was not meant to be a question. Why should every lawyer learn mediation? It is a statement. Every lawyer should learn mediation. Before we come to that point, why are we talking about this? Why mediation is the talking point? If you look at the last 10, 15, maybe 20 years, you will see that several developments are happening in the mediation front, both globally as well as internationally. Internationally as well as nationally. You see a legislative degree in Italy as early as 2010. Then you see a Mediation Act in Malaysia in 2012, then in Singapore, in Hong Kong, in Brazil, in Ireland, all of these happening in the 2010s. And these are very specific statutes for mediation. It's not that mediation acts or statutes mentioning mediation was not existent before that. It's just that since 2010, we see a gradual progression of the countries, the jurisdictions towards making mediation more regulated through specific statutes in those countries. And one of the latest developments which we are more familiar with is the Mediation Act 2023 in India. And I think the landscape of mediation, despite the fact that we had a Conciliation Act since 1996, has totally changed because we have now a specific statute on mediation, the Mediation Act. Although it has not been in force yet, but we hope it's going to come into force. So the point I'm trying to make is you see a lot of national developments happening all across the globe, especially in India. Then you also see international developments. You see UNCITRAL model law on mediation coming up. You see mediation rules of UNCITRAL released in 2021. And most importantly, I'm sure most of you might have heard, if you're familiar with mediation, that Singapore Convention on Mediation. And that's probably the biggest document or development in the international scene since mediation has come into the fore since 1970. We also see post-2023 developments. Say, for example, in the Sri Lanka, they have enacted the Sri Lankan Mediation Act in 2023. That is to give force to the Singapore Convention on Mediation. We see amendments in UK, we see amendments in Australia, we see amendments in the US regarding mediation. The point again I'm making is in every developed jurisdiction, the legislatures are taking mediation very seriously and trying to enact a specific exclusive law on mediation. Then coming to India, you will see a lot of judicial encouragement for mediation. On a daily basis, we have a knowledge and communications department, and they pick up almost on a daily basis developments in mediation, which reports high-profile cases being referred to mediation by the Supreme Court. I'm sure you read that on a regular basis. That is happening. Then the judiciary itself, through the judicial statements, when I say judicial statements, statements in the judgment itself, they are coming up with statements which encourage mediation, to some extent persuade parties to go for mediation, telling parties that this is the way forward rather than litigating, unless, of course, you can't mediate. So a lot of judicial encouragement happening, either by way of judicial statements or by way of policy statements or by way of actual reference. When you talk about policy statements, you may recall that the then Chief Justice Chandrachud asked the government to start mediating instead of litigating. That's a huge step. The reason why it's a huge step is government is one of the biggest the clients of the judiciary. It's either on one side. It's on the one side of most of the cases which comes to the courts. And when the government is asked to mediate, then you are talking about a major shift from litigation to mediation. I'm not saying that it's going to happen overnight, but that's definitely a direction where mediation may want to travel. The biggest encouragement or biggest support of the judiciary is not in the statements. It's actually in the referrals. If you look at the example of Kerala Mediation Center, in 2009 or 2008, when it started, you are looking at about 1,000 cases annually. Just 1,000 cases annually referred by courts to mediation. And now we don't have the 2025 records, but in 2023, that number has increased gradually to 50,000 cases. And I'm sure the latest numbers are much higher. So, and that could be the biggest encouragement a court can give. When a case comes in front of you, the judge says, go and try mediation first. And so you can see a great judicial encouragement happening in favor of mediation. That's another thing. Another development is where you see campaigns conducted by, I think, NALSA in association with MCPC, like Mediation for the Nation campaign. And I think there were 2 phases of that campaign. A number of cases, many clients, many lawyers are persuaded to present their case for mediation rather than litigation. Appropriate cases, of course. And all of these shows a great judicial support for mediation. And then you see expanding infrastructure for mediation. Sometime before, maybe 10 years before, we haven't heard of many mediation centers in India or globally. There were few like JAMS and CIMI and SIAC from Singapore, International Mediation Institute. There were some of them globally existent, and even in India, there were some court annex mediation centers. But the number of mediation centers, which means the places where you can go and mediate, have increased many fold. Private mediation centers, court annex mediation centers, the numbers are huge, and that's a great development, what's happening with mediation. So it says that over 800 court annex mediation centers are existing in India, out of which 78 are in Kerala. Kerala has a very structured court annex mediation centers. In addition to all of these states having their own mediation centers, court annex mediation centers, they also have a lot of private mediation centers, and that's also coming to the fore. Another development which happens is in terms of awareness and education. Of course, ADR was a subject since 2000 in the LLB, but the specific training programs like Mediation Masterclass, which we organize, the Mediation Society organizes, is a recent phenomena. There are a lot of events, lectures, seminars, workshops, competitions, all of these happening in the last maybe 10 years. We see a lot of publications, articles written, journals. Look at the Mediation Conversation series, which we do on a regular basis to promote mediation. And most importantly, mediation has been made a compulsory subject in the LLB since 2021, if I'm not wrong. So things are changing. Mediation is emerging as a major dispute resolution process. Different people are... The judiciary, the legislature, the infrastructure, the state, the government, everybody is getting involved in it and encouraging mediation. And the major thing I see is that the attitudes are changing. The culture is changing. Look at the support of the lawmakers and policy builders. Look at number of judges. More and more judges are referring disputes to mediation. The bar, the lawyers used to resist a lot more. They felt, for whatever reasons, they believe mediation is going to take away their livelihood to some degree. So they were very opposed to mediation, and I don't see that kind of opposition anymore from the bar. And most importantly, clients are getting very keen on mediation. They are becoming very knowledgeable. They are becoming very informed. And clients, especially the business clients, want to try mediation before they go for litigation, because they think that litigation and arbitration can take a lot of time, and they know that it will take a lot of money. So that is happening, and all of these changes in the cultural, the cultural and other changes are transforming the mediation practice. Number of sectors which are using mediation, say for example, IP, consumer, family, the commercial cases, electronic disputes, community disputes, many of them are using mediation to resolve their disputes in those sectors, which was not there before. IP is highly one of the areas where mediation is being increasingly used is IP. You will also see the client profiles. Initially we used to use mediation for small profile cases, for family cases. But now the profile has changed. Small businesses are using, large businesses are using, consumers are using. So the profile is changing. We also see the study of mediation is taken a lot more seriously. It's not anymore a legal only subject. The neuroscience has come in, behavioral science is coming in, psychology is coming in, all for very good reason. So because of all these, the mediation is developing as an interdisciplinary academic subject and even a professional subject. You will in the early days, we see contracts having a jurisdiction clause, a dispute resolution clause, which says that if there is a dispute, it goes to the courts in a particular place, in Mumbai or Kerala. And then we saw a shift towards arbitration. Then they put in arbitration clauses. Now the trend is becoming more like multi-tier dispute resolution clauses. They don't just put in court or arbitration. They say, if there is a dispute under this contract, we want to refer that to mediation. And if mediation doesn't work, then maybe we go for arbitration or litigation. So multi-tier dispute resolution clauses are becoming a lot more common. Prescription of mandatory pre-litigation mediation. You are all aware of this Commercial Courts Act, where before you can litigate certain cases under the Act, you may have to mediate. You will have to mediate. So these kind of compulsory pre-litigation mediations are also transforming the way mediation practice is happening. The potential, as I mentioned before, the potential use of mediation in disputes involving government. Again, if government starts mediating, the mediation practice is going to transform in a very big way. The reason is simple. Government is on one of the sides in most of the cases. We also see grassroots level and community level disputes being referred to mediation. We see mediation advocacy coming to the fore. I'm sure that that is something which we are focusing on in the next session, in the next part of this series on lawyers' role in mediation. So we will be talking about mediation advocacy. We also see a lot of supporting legislation coming up, different styles of mediation coming up, innovation and technology coming into mediation. It's not anymore in-person mediation. It could be online mediation, online-only mediation, hybrid mediation. All these technologies are coming to the fore. So my point might have taken a long time to make that point. The point is, the recent developments across the world, particularly in India, suggest that mediation is emerging as the preferred tool for dispute resolution. Legislative developments, international developments, judicial encouragement, expanding infrastructure, growing awareness, changing attitude, and transformation of practice. All of this is a clear indication that mediation is here to stay, and mediation may be the future of dispute resolution. Now, many of us think that mediation is coming to the fore for the simple reason because we have too many backlog. Courts have too many pending cases, and therefore we have a lot of cases pending. And to resolve that pending backlog, mediation is coming to the fore. I don't think that is correct. And I know that Aditya has very strong views on that. Aditya, do you agree with the proposition that mediation is coming to the fore only because it is intended to clear the backlog of the courts?
Good evening, sir. Good evening, everybody. Well, it's interesting that this question was posed to me because as a lawyer who's practiced for the past 10 years and as somebody who has taught a lot of students mediation and ADR, one of the primary things that we all start with is mediation was introduced to lighten the burden on the judiciary, right? This is like a caption or a tagline for mediation. But unfortunately, this is not true. Now, the best answer as to why this is not true or why mediation has other reasons or why it has certain advantages was given to me by a client. Now, let me just narrate what happened. So, recently a client approached me. They were a developer. So, they wanted to purchase a huge extent of property and develop a certain project there, including malls, shopping complexes, a gaming arcade center, etc. So basically they wanted a multi-tier agreement, contracts, multiple contracts to that extent, involving multiple stakeholders, having a lot of interest that were being affected. So all of these terms and conditions were discussed in detail with my client, but ultimately the one point on which they continuously insisted was that, sir, irrespective of what you include in the contract, we want a mediation clause. So as a lawyer, I was a little taken aback because it is usually the lawyer who puts to the client what his options are, like go for litigation, let's try mediation, let's try arbitration. So the first time in my profession, the client had put to me that he preferred mediation or that he wanted mediation as the only condition for dispute resolution in his contract. Automatically, my first question was, why do you insist on mediation? Now, surprisingly, he started enlisting the advantages of mediation. So to my surprise, what you have to understand is every person in the commercial field, these traders, these investors, these developers, people who are actual entrepreneurs, they have already started realizing the advantages. The first thing that he said is, sir, this particular transaction that we are entering into with multiple stakeholders. We have a lot of people that we have to transact with, right? So we have to ensure that whatever happens, this agreement, this negotiation, this mediation or this discussion or dispute resolution has to remain within our control. You file a case before a court of law, it's either a win or a lose. Yes, there's no in between when you go to a court of law. There is no controlling how the particular case goes. So my client specifically wanted some active involvement in this dispute resolution. They wanted to ensure that whatever happens, they had some say in the final outcome of that particular dispute resolution. Now, in terms of, let's say, legal jargon, we call this party autonomy. So even though they did not know it, they did not know the word as such, they knew the idea that mediation would ensure party autonomy. It would give you that kind of freedom while going into dispute resolution. They further told me, sir, we are entering into contracts with 25-30 people. We have to make sure that whatever disputes are being resolved, it has to be confidential. We cannot risk all of these getting leaked. We cannot risk the other parties coming and questioning us about our agreements with the other parties. Granted, I had to accept and I had to concede that confidentiality was also guaranteed in mediation. So I asked, what else? Automatically they said, sir, you go to a court of law, sir, how long do you think it will take? How much time and money do we have to waste? And I said, well, I can't argue with you. There are also civil disputes often take 20 to 30 years at the very least, right? All of us know that. So automatically he said, all of this considered, sir. And finally, just one more important point I'd like to raise, sir. Even if we don't ultimately win this case, I can ensure that the very next day, the parties that I'm entering into this dispute resolution with, I can still face them. I can still discuss my problems with them. The relationship does not get affected. There is no souring of relationship with the other parties because all of these stakeholders I have to see tomorrow also. If I go to a court of law, if they win or if I win, if they lose or I win, one or the other party obviously loses face. They get angry, trade gets affected, their commercial aspects get affected. So all of these aspects, just consider this is an ordinary man. He is an entrepreneur, obviously. He has absolutely no idea about the intricate aspects of mediation, the elements of mediation. But he sat there enlisting to me the confidentiality aspect, the party autonomy aspect, the fact that there is usually a win-win solution, the fact that it ensures that relationships are continued even despite the dispute that happens between the parties. All of these points clearly showed that mediation has certain special characteristics, certain inherent and innate traits apart from lightening the burden on the judiciary that make sure that dispute resolution has to be done through mediation. It is not just lightening the burden on the judiciary, right? There are specific traits that mediation has which draws people to mediation, irrespective of the burden on the judiciary. Now, another aspect that the clients don't know, as lawyers, as litigants, as people in the legal field that we know, is apart from, as I was saying, apart from or in addition to what we had before, the Mediation Act 2023 has definitely given us a lot of openings. We had a lot of barriers, we had a lot of restrictions to mediation in the erstwhile period because the enforceability aspect was a huge barrier. The lack of a structure, the lack of a hierarchy, the lack of a, let's say, an apex body, a regulator like the Bar Council of India that we have, all of these deficiencies posed a real threat to mediation in the erstwhile period. Now that the 2023 Act has come into picture, all of this has been taken care of. Yes, we have a mediation council, not yet implemented, but then very soon all of these will come into picture. So the mediation council as the apex body to control, to regulate, to monitor all of those aspects of the mediators, to make sure that these are all done in tune with the law and specific rules that will be formulated in due course. Yes. And then enforcement aspect has also been dealt with. Now a mediation settlement agreement has the same effect as a court order or a decree, so that part is also taken care of. So all the, let's say, barriers or limitations that once posed a threat or once posed a, let's say, a hesitant, that made parties hesitant to get into mediation, have now all been taken care of or addressed by the Mediation Act 2023. So it's a huge advantage compared to ordinary litigation. All of these make mediation a much more better option than ordinary litigation, right? In addition, imagine the client that came to me, he was somebody belonging to the commercial industry, he was an entrepreneur, he was a businessman. These people have already realized that if we want to save our time and money, cut our losses, make sure that we get effective remedies in a timely manner, they have already realized that mediation is our only go-to option. Litigation and all the other, let's call them conventional modes of dispute resolution, as you all know, you know what happens, right? Conventional modes of litigation, you file a case, it takes 20 to 30 years to come to its logical conclusion. Now, this you have to read it in by keeping in mind there are already at least 5 crore cases pending before the lower judiciary already. The statistics very clearly point out that the pendency of cases is already so high that the courts cannot complete it even in the next 3 to 5 years, even if a single case is not filed. So even if no new cases are filed, they still take 3 to 5 years to complete the existing pendency. So imagine, under such circumstances, when nearly 3 crore cases are being filed in addition to the existing pendency every year, the likelihood of your case being completed in maybe, let's say, 2 or 3 years is very small. Yes. Additionally, just imagine the litigation fees that you have to incur. As far as commercial litigants are concerned, as far as entrepreneurs are concerned, they have a lot of other aspects also. Let's say a trader, for example, a trader who has to store his goods in a warehouse. He has to go for a litigation, obviously, but consider the warehousing cost. If it's at a dock or a ship, or if he has his demurrage charges, dockage charges, lots of other additional burdens which over a period of time can pose a huge burden to him. So commercial industry, commercial litigants, people in the business field especially, have already taken a liking to mediation. They have realized that going for litigation is not the only option. Going for mediation would ensure a more amicable settlement for them, give them better options, give them more control over the final decision. And the worst part of all of this is conventional litigation. Just consider, you file a case, there's a 50-50 chance that you win or you lose. You lose everything. In mediation, we have the option of discussing and negotiating with our opposite party. We have the option of coming to an amicable settlement. You don't lose completely. That is why we call mediation a win-win situation, right? So this advantage is huge. This is very important as far as business professionals are concerned, as far as entrepreneurs are concerned. Now, considering all of these, inevitably, industrialists, commercialists, entrepreneurs have already taken up mediation. Now, it is only a few people, it is very soon people, ordinary common man, whether it's a family dispute, whether it's a labor dispute, whether it's an IP dispute, as sir was saying, whether it's a property dispute, they will also start realizing that why do we have to go for litigation? Instead of the question that we pose now, why every lawyer must learn mediation, the question soon should become, why does every lawyer prefer litigation? They have to first prefer mediation, right? So this has now come to that kind of a turning point. All the aspects have now changed. The mediation, which was once taken as the lesser option, which was taken as probably the second alternative, that is being preferred by more and more people. The existing legal machinery has finally started yielding. As sir pointed out, the present Chief Justice of the Supreme Court, Suryakant sir, the Chief Justice of the Kerala High Court, they've all started yielding and surrendering to the fact that mediation is definitely a better alternative to ordinary conventional litigation. Now, all of these aspects are very important, but then they're all really technical and legal aspects. The most foundational aspect, why mediation, or why every lawyer must learn mediation, the one aspect that most of us often forget or don't go into. Mediation is a very logical and natural thing for all human beings, right? Just consider this. Two siblings who have a fight, they first try to negotiate among them, find out a common solution. If that doesn't work out, the first thing they do is call their mother, call their father, call in a grandparent. They act as a mediator, come to the solution. Same thing happens if there's a property dispute, if there's a neighborhood dispute. The first thing that they do is try to talk to each other, negotiate. If that doesn't work, call in a village headman, call in a senior member of that particular fraternity, call in somebody to aid and assist them. So this was not something that was taught to them, right? Right from time immemorial, talk about your Puranic times, mediation has always existed in our own lifebloods, in our own history. So this is not something that has to be taught to people. Now this is also primarily, personally I feel, why people are now moving more towards mediation. They've understood that, okay, this was always there in our system, this was always there in our history, why don't we come back to it? This is never gone. As something that has existed since time immemorial, I think mediation is now here to stay. Mediation has now made its mark especially in the Indian legal fraternity. And I honestly believe, sir, the idea that mediation is intended to lighten the burden has now completely gone away from the minds of the common man. Though this idea is probably being still taught in law colleges, that has gone from the ideas of the common man. They have now started realizing the true importance of mediation. Back to you, sir.
Thank you. And I guess we all agree on that point. I was trying to enlist the number of developments happening in the last 10 to 15 years, and Aditya was trying to give the reasons why these developments are happening. And of course, backlog of cases in the courts is definitely one of the reasons, but that's not the main reason. There are innate, as he mentioned, there are innate reasons, innate features of mediation, which makes it attractive to commercial and personal clients. We also saw the last point you made on mediation being one of the most logical and natural way of resolving disputes, even within an informal setting, is probably one of the reasons why mediation is picking up. So we found the developments, we found the reasons for the developments. Great reasons, but I still don't think that mediation has picked up enough. Given the kind of support mediation has received, as I mentioned, from the courts and the statutes and the government, still we hear a lot about mediation in the media. We hear in the court annex mediation centers, all are great, but I don't think it has reached the right potential which it is capable of. One of the reasons, I think there are many reasons for that. One of the reasons is very systemic, that lawyers are not given their place and position in mediation. It could be a system fault. It could be a fault of the lawyers. We won't go into the reasons why the lawyers haven't been involved in mediation as much as they should. If the lawyers are not involved enough, mediation is not going to take off. Simple reason. Lawyers are by far the largest stakeholders in the legal industry. And if they are not supporting, if they are not benefiting, if they are not being rewarded for being in mediation, mediation will not take off to the potential. I'm not saying that mediation is not working now. Mediation may be working, but definitely very far from the potential. So I think that brings us back to the reason why we organize this event, or many events which we organize on a regular basis. Lawyers have a place and potential in mediation, and we ourselves don't realize that very much. And before I say how lawyers can get really involved in mediation, I want to explain why. Of course, the bigger answer lies in the money. We are all professionals, and as professionals, I think by definition we charge for our services, and we need the money, and we don't see the money. But the potential of money in mediation is high. Some estimates, these are not really accurate estimates, scientific data, but rough estimate shows that there are about 4 lakh crore rupees involved in the legal industry. That's a lot of zeros. I'm not going to ask the number of zeros in it, simply because if your math is as good as mine, you will take 2 days to do that. So 4 lakh crores is the potential or the worth of the legal market in India. And a lot of cases are pending in the courts. And most of those cases, or many of those civil cases, are amenable to mediation. So think about mediation being used instead of litigation in those cases. Then the amount of the share of mediation in the large legal market of 4 lakh crores will definitely increase. And if you learn mediation, you may be able to stake a claim in that huge amount. I'm sure you don't mind having a small claim in that 4 lakh crore worth of the legal market. So if you ask me the single answer why every lawyer should learn mediation, the simple answer is this: because of the money. We professionals are in the profession for money. Of course, I'm not ruling out all the pro bono work and altruistic efforts you do, which are all can be termed as success. But one of the ways how we define success in a profession is probably money. I mean, we like it or not. And there is a lot of money to be earned in mediation. So that is my first answer. But how do you get the money out of it? Just learning a mediation doesn't mean that you can make money. Nobody is going to pay you for learning mediation. You have to realize that there are at least 4 dimensions where you can put yourself to use in mediation as a lawyer. First, it opens up some specialized jobs. We all know mediator. You can become a mediator. You don't need to be a lawyer to become a mediator, by the way, but we dominate the industry, and hopefully it stays that way for the interest of the legal community. So mediation is a lot of mediation by definition is facilitated negotiation. Parties negotiate between themselves, and a third party, neutral, facilitates that negotiation so they can come to an amicable solution, if at all. So as a mediator, you have a lot of things to do. You have to serve as a neutral who assists the parties in resolving their disputes. The role of the facilitator is to create a structured and a productive environment where they can have a dialogue, communicate with each other, help the parties identify their interest, explore options, and move towards an amicable solution. So that is the role of a mediator. So when you learn mediation, and with the right training, with the right credentials, you can become a mediator. So that is one of the specialized jobs which is available to lawyers. And all of us are aware of that. There is also another specialized job which is available for lawyers, which is the mediation advocate. We are less familiar with that. I know that the term is increasingly becoming familiar to you, but still less familiar. It is no less central to mediation than mediator. So as a mediation advocate, what you do is you represent a party in mediation. I know that there are anecdotal stories which says mediators don't like lawyers with the parties because they confuses the parties, and they don't help in the settlement as fast as the mediator would like to. But those are anecdotal stories. Lawyers have a major role to play in mediation as a mediation advocate. They can represent the party in the mediation, and that representation could be in many ways. It could be by helping them draft the mediated settlement agreements. It could be by advising them when to go for mediation. It could be by helping them enforce a mediated settlement agreement. And most importantly, it could be by making them negotiating on their behalf. When you go into a mediation, again, something which we don't understand fully is that mediation is facilitated negotiation. People negotiate inside. It's not that parties cry, parties vent their emotions, and then mediators suggest something and the parties accept or not accept. That's not mediation. Parties go in with or without representatives, with or without the lawyers, and negotiate a proper full-blown negotiation. It in itself is an art, it in itself is a tool, and they negotiate a settlement. A mediator facilitates that. In negotiation, I think the lawyers have a major role to play. So as a mediation advocate as well, it is a specialized job. If you learn mediation, that is something which you can pick up as well. Then, of course, there are many other related roles like mediation trainers. I try to act like one, pretend like one. Mediation training is becoming a lot more frequent, common, and in demand. People want some training in mediation. So as a mediation trainer, it's a specialized job. You can pick it up. Then there are a lot of mediation centers, which I mentioned before. A lot of mediation centers are coming up, and all of these mediation centers need their CEOs, registrars, institutional administrators. All of these are specialized jobs. So, we were talking about how you make money from the mediation market. And these are some ways of making money by becoming a mediator, by becoming a mediation advocate, by becoming a mediation trainer, and maybe becoming a mediation center administrator. That's the first part of it. Now, I think more important for a lawyer is the fact that I believe learning mediation will help you make yourself a better lawyer. Forget about the specialized jobs of mediators and mediation advocates. To be a general litigator or a corporate lawyer, training in mediation helps you better. And I'm sure by now you realize that legal profession is fundamentally about problem solving. Clients don't come to you saying that I want to go to court. They come to you with their problems and they want effective solutions. And as a lawyer, you need to have a set of tools and processes to address those problems. And mediation, being one of the emerging dispute resolution process, is an important part of that toolkit. You need to know what mediation is and what mediation can do so that you can advise your client when he comes to you with a problem that mediation, if at all, is the most appropriate one, and maybe you may want to direct your client to mediation. I'm not saying that you should direct every single client comes to you asking for a solution for a problem to be led to mediation. It may not be appropriate in many cases. That's another story. But in appropriate cases, you may be required or you may be expected to refer them to mediation. To know when to refer a client to mediation, you may need to know mediation. You also, when you learn mediation, one of the things you learn in mediation is you learn a set of critical skills. Critical thinking, creative thinking, coping with stress, coping with emotions. All of these are life skills, which I'm sure UNICEF, if they had a chance, would have taught you in the secondary school level. So effective communication, managing interpersonal dynamics, coping with these emotions and working with competing interests, all of these things, along with your skills as a lawyer, like adversarial skills used in litigation and arbitration, is going to equip you with a lot more tools to do your work properly. So all of these skills, if you look at each of these skills which you learn from the mediation training, are central to effective lawyering. They help you in your day-to-day legal practice in many, many ways. For example, think about creative thinking. It helps you develop effective solutions, maybe effective strategy in a court or before an arbitrator. active listening, that's another skill which you pick up during mediation training, deepens your understanding of what the client is saying, what is their perspective, and even the opponent's perspective better. Your ability to ask appropriate questions, that's again another set of skills you develop while you train for mediation, help you uncover what exactly or truly matters for the clients. And of course, the ability to manage interpersonal dynamics enables you to handle difficult people and conversations. So my point is, mediation strengthens both what you do as a lawyer and how you do it, making you more attuned to your client's needs and more effective in delivering outcomes. So you become a better lawyer, even though you don't want to specialize in mediation. Let me stop here and call Joel. Joel has a distinction, a unique distinction of becoming one of the youngest MCPC mediators. At a very young age, he just completed his LLM. He's also a practicing lawyer. So he has, I think he has taken a bite of both cherries, the mediation as well as litigation. And maybe you could share with us, Joel, your views on how training in mediation has helped, if at all, helped you become a better lawyer.
Thank you, sir. And yes, you have put me on the right spot, I would say, because I believe this is a part where I actually have something to say about. Sir, Varanyu, mediation makes you a better lawyer. And I want to be honest with everyone who is listening, who is in this Zoom call right now. When I first heard that, like 2-3 years back, when I first heard that, I did not buy it. That did not sell on me particularly. To me, back then, mediation, it sounded like a side gig that you would have, something that you can put on your profile, അല്ലെങ്കിൽ a certificate that you can put on your wall, അല്ലെങ്കിൽ CV-യിൽ നമുക്ക് ടിക്ക് ചെയ്യാൻ പറ്റുന്ന ഒരു box. And I genuinely did not think it had anything to do with how good a lawyer I would be. So let me tell you what changed my mind. When I started out, I had one move, the argument. To find the strongest point, build everything around it, and push until the other side gives up. That is what we were trained to. That is what I was trained to do. Law school taught me to argue. Litigation taught me to argue harder. But litigation and law school sharpened my skills in arguing, and I was pretty good at it. It was rewarded. But here is something I think a lot of you might have felt and never said out loud. നമ്മളെ കേസ് ജയിക്കും and we still don't feel happy about it. We still does not feel like it is a win. The order may come our way, the file may close, the client may walk out flat. പക്ഷേ both the sides somehow feel worse than they did when they came in. And for years, കുറേ വർഷം ഞാൻ വിചാരിച്ചെന്താന്ന് വെച്ചാൽ that അത് നമ്മുടെ ജോബിന്റെ കൂടെ വരുന്ന ഒരു ഡിസ്ക്രിപ്ഷൻ ആണ്. I thought it came with a job. I thought in this job scenario, somebody has to win, somebody has to lose. Somebody has to lose. And I was not, I thought I was right back then, but mediation taught me something else. Mediation taught me that I was looking at it wrong. Mediation taught me that I should have been asking, what does this person, what does my client actually need, instead of asking, how should I win this? കാരണം ഞാനിത് പറയാൻ കാരണം കുറച്ച് നാൾക്ക് മുമ്പ് ഏകദേശം 1 year back, a client walked in. I can't say he walked in, he barged into the office. He was a small time manufacturer who is based out in Bangalore. So പുള്ളിക്കാരന്റെ വിഷയം എന്താണെന്ന് വെച്ചാൽ, another company in his line has a brand so close to its brand that the customers are mixing the two up. So he wanted an injunction. He wanted to file an injunction. He wanted to destroy the other company completely. He wanted them off the shelf. And he wanted it that particular week itself. The old me, before I knew anything about mediation, would have taken it all down, filed it, accepted his demand, and filed it then and there. It was a decent case, 3 years of litigation sitting right there. പക്ഷേ this time I stopped. എന്താണെന്ന് വെച്ചാൽ, instead of asking what he wanted me to file, ഞാൻ പുള്ളിയോട് ചോദിച്ചു, forget the injunction for a second. So what is actually keeping you up at night? What is actually bothering you? And he went quiet. Then he went quiet for a while, and then the real thing came out. He told me, Beta, I'm not trying to destroy the other company. I'm just scared that people will buy their product, confusing it with my product, find it cheap, find it faulty, and blame me for it. He told me that it was his name that he's worried about. He told me that it was his reputation that he was worried about, not the existence of the other company. See what happened here. See, I stopped talking and I listened. ഇതാണ് സാർ നേരത്തെ പറഞ്ഞ active listening എന്ന് പറയുന്നത്. I did not listen for the weak points which we were trained to do. I listened for what was underneath. If I had only heard the demand, if I had only heard the demand that he wants to destroy the other company, he wants an injunction, I would have spent 3 years of his money chasing on an injunction that he did not even really want. And after that, I asked him one more thing. If the confusion stopped tomorrow and your name was safe, would you still need them off the shelf? Would you still need to destroy them? He thought about it for a while and he told me, no, not really. That one question and the whole thing turned. This guy literally barged into the office. He came in wanting to break the other party and now he wants to sit at the table. See, there I did something that I would have never done before if I never had a mediation training. Instead of treating the other side as the enemy, I asked their lawyer what their client actually needed to protect. It turned out that they had just spent a fortune, they had spent a lot of money on the packaging and could not afford to throw it away. And right there, I could see it. Because there was a deal. I could see a deal where nobody had to lose. Because here's the most useful thing I have taken from mediation, most useful thing I learned from mediation, that there's a difference between what people demand and what they actually need. എൻ്റെ ക്ലയന്റിന്റെ ഡിമാൻഡ് എന്തായിരുന്നു? പുള്ളിക്കാരുടെ ഡിമാൻഡ് വാസ് ടു ടേക്ക് ദി ഓപ്പോസിറ്റ് പാർട്ടി ഓഫ് ദി ഷെൽഫ് ടു ഡിസ്ട്രോയ് ദം, ആൻഡ് ദി അതർ പാർട്ടി ദേ വെർ നോട്ട് റെഡി ടു ചേഞ്ച് എനിത്തിങ്. ദാറ്റ് വാസ് ദർ ഡിമാൻഡ്. ഈ രണ്ട് കാര്യങ്ങൾ ക്ലാഷിംഗ് ആണ്, ആൻഡ് ദോസ് ടു വിൽ ഫൈറ്റ് ഫോർ എവർ. ദർ ഇസ് നോ റെസൊല്യൂഷൻ ടു ദാറ്റ്. ബട്ട് പുള്ളിക്കാരുടെ ഇതായിരുന്നു അവരുടെ ഡിമാൻഡ്. ബട്ട് ദ നീഡ് underneath the demand, the need was a clean need, and the need was not to waste their money. One party, my client, wanted to protect his reputation and name. The other party did not want to lose the money they had invested. And these two do not clash at all. So we built around that. The other party, they changed their colors, they changed their label so nobody could confuse the two. They kept their packaging shape intact, so their money was safe. So we wrote it into a settlement which can be enforced like a court degree. Here, എൻ്റെ ഒരു എക്സ്പീരിയൻസിൽ ഈ രണ്ട് പാർട്ടികൾ they came into the room very angry and they left the room very satisfied. Nobody lost. See, I'll be very honest about what mediation did to me, because that is a real point here. It taught me to stop pleading, to fight. Today, ഞാനൊരു കാര്യം ഫയൽ ചെയ്യുന്നതിന് മുമ്പ്, before I file anything, I ask a basic question that I never used to ask. What does this person actually need? I see settlement that is sitting right there, months before I used to see it before. I read the other side for what they're protecting, not just what they had been shouting. And I can tell a client, honestly, when a courtroom will not give him what he's really after. That makes me a sharper lawyer, I think. And here's the proof. That client came back to me after 2-3 weeks. The next problem he had, he came back to me. He came straight back to me because he trusted I would get him what he needed, not just the fight that he had asked for. So, sir, നേരത്തെ പറഞ്ഞ പോലെ mediation makes you a better lawyer. I used to hear it as a tagline. I used to hear it as a brand. I used to hear it as something that is trying to sell off to people, which I do not hear it as a line anymore. I hear my own day-to-day work, listening to what is underneath, asking the question that opens a door, reading what the other side really needs, telling a demand apart from what, telling the difference between a demand and a need. None of that, I believe is a soft skill, because they are the most practical tools I have right now, and I believe that they make me sharper in every room, courtroom included. Thank you, sir. I'll hand it back to you.
All right. Joel, I think that's a real life experience, especially for somebody who has started out with a practice. I suppose if it could be this helpful, I'm sure that in the long term, for most people, it will be beneficial. So what we were trying to say is that as a lawyer, you will benefit from becoming a mediator, a mediation advocate. Then we also saw that even if you don't want to be a mediator or a mediation advocate, you may benefit because it will help you in your general practice which is central to lawyering. Now, the value of mediation, I think, extends beyond legal practice. And I don't think all of you will remain in traditional legal practice throughout your career. Many of you do. And even if you do, your role will evolve. Sometimes you move up to the judiciary or move into the judiciary, take up an in-house position as a lawyer, or work in the policy or management or regulatory spaces, all connected with law, but slightly different from legal practice. You may also step into business or organizational leadership. Across these roles, conflict and the need for conflict resolution is going to be the same. An understanding of mediation improves how you deal with these situations. As a judge, for example, it helps identify cases suitable for mediation. By assessing the mediatability, the party readiness, they will be able to better judge, and they can guide the parties towards constructive engagement. As an in-house counsel or in a managerial position, the focus shifts from resolving issues efficiently while preserving relationships, often with time and cost constraint. And in-house lawyers, by the way, are under a lot of stress from their bosses, the company CEOs, to make sure that disputes go away at the cheapest possible way, at the fastest manner they can. So mediation can help them. At least the knowledge of mediation will help them know that they have exhausted all methods before they go for lengthier arbitration or litigation. And mediation also, I think, shapes your approach in difficult situations. It equips you how to deal with people, how to understand the positions, work through competing interests, and move the discussion towards resolution. So again, like I said, in the case of a lawyer, mediation has become a portable professional competence grounded on a set of skills that remain relevant across the roles. So you may want to graduate yourself to different roles from becoming a lawyer. Mediation is going to help you. The skills you learn in mediation is going to come with you and help you in whichever profession you choose to, including a judge, including an in-house counsel, including an HR manager, including a company CEO. And I think one final point on how mediation learning is going to help you is how it helps you as an individual. A slightly lesser point, less professional, but I think as an individual, the value of these skills you learn from mediation is not limited to professional context. It helps you as an individual as well. Say, for example, mediation helps you to hone a set of life skills. As I mentioned before, all those life skills which the UNICEF and the UN has been propagating to the schools across the globe for them to teach their students are the ones which we are learning in mediation. You learn about how to listen carefully, how to understand perspectives, how to navigate disagreement without escalating the situation, how to work towards solutions which are acceptable to all those who are involved, how to cope with emotions, how to cope with stress, how to make decisions, how to solve problems. All of these are life skills. And these skills extend beyond courtrooms or professional settings to your everyday life, in your family, in your friend circle, in your workplace, in your community, everywhere where conflict is there, which is everywhere anyway. You will need these skills to navigate this better. I'm not going to say that you will become a nice person. That's a value-based judgment. What I'm saying is that you may become an effective individual when it comes to conflicts in the communities you live in. And so you not only become a specialized mediator or mediation advocate or become a better lawyer or a better professional, you may also become a better, more effective individual. And so these are the reasons, or these are the reasons why you should be learning mediation as a lawyer. And now, I know that Munira has a story to share with us in this context of more than a professional setting, in a personal context. Munira, do you want to share with us the story you have?
Yes, sir, of course. Actually, honestly speaking, എനിക്ക് റീസെന്റ് സംഭവിച്ച ഒരു സംഭവമാണിത്. എന്ന് പറഞ്ഞാൽ ഞാൻ ലോ കോളേജിൽ ലാസ്റ്റ് ഇയർ സ്റ്റുഡന്റ് ആണല്ലോ. അപ്പൊ നമ്മള് ഹോസ്റ്റൽ ലൈഫ് എല്ലാം എൻജോയ് ചെയ്ത് റൂംസ് ഒക്കെ ഷെയർ ചെയ്തായിരിക്കും നമ്മൾ ലൈഫ് മുന്നോട്ട് പോയിക്കൊണ്ടിരിക്കുന്നത്. അപ്പോ ഞങ്ങളുടെ റൂമിൽ 4 പേരാണ്. ഞങ്ങള് ഇപ്പോ സ്പ്ലിറ്റ് ചെയ്താണ് നമ്മൾ റൂമിന്റെ ബില്ല് കാര്യങ്ങൾ അല്ലെങ്കിൽ ഇലക്ട്രിസിറ്റി ബിൽസ് അങ്ങനെയെല്ലാം നമ്മൾ അങ്ങനെയാണ് ഷെയർ ചെയ്തോണ്ടിരുന്നത്. പക്ഷെ എല്ലാം നല്ല സ്മൂത്ത് ആയിട്ടായിരുന്നു പോയിക്കൊണ്ടിരുന്നത്, ഒരു കുഴപ്പമൊന്നും ഉണ്ടായിരുന്നില്ല. ലേറ്റ് ഒരു 3 months മുന്നായിട്ട് വൺ ഓഫ് മൈ റൂംമേറ്റ് എന്ത് ചെയ്തു, പേയ്മെന്റ് ചെയ്യാൻ ജസ്റ്റ് ലാഗ് ചെയ്തു. അപ്പൊ നമ്മള് ഓട്ടോമാറ്റിക്കലി സ്പ്ലിറ്റഡ് ആണ് ചെയ്യാറ്. ഇങ്ങനെ ആരെങ്കിലും പേയ്മെന്റ് ചെയ്തില്ലെങ്കിൽ കവറപ്പ് ചെയ്യും, ബാക്കി 3 പേര് കവറപ്പ് ചെയ്താണ് പോവാറ്. 1 month ഞങ്ങൾ വെയിറ്റ് ചെയ്തു, സെക്കൻഡ് മന്ത് ആയി, തേർഡ് മന്ത് ആയപ്പോ നമ്മൾ കവറപ്പ് ചെയ്യണതിന് ഒരു ലിമിറ്റ് ഉണ്ട്. നമ്മുടെ കയ്യിൽ നിന്നും എക്സ്പെൻസ് പോവാണ്, വി ആർ ടേക്കിംഗ് ഹെർ ഷെയർസ് ഇൻ അവർ ഫ്രം അവർ. അപ്പോൾ അത് ഒരു പ്രോബ്ലം നമുക്കായിട്ട് ക്രിയേറ്റ് ചെയ്ത് തുടങ്ങിയപ്പോ ഞങ്ങൾ പറഞ്ഞു നമുക്ക് ശരിയാവില്ല, നമുക്ക് അവളോട് സംസാരിക്കണം. ഞങ്ങൾ ഇച്ചിരി ഫ്രസ്ട്രേഷൻ മോഡിൽ ചൂടായിട്ട് ചെന്നിട്ട് ചോദിച്ചു, ഇത് മോശം പരിപാടിയാണ്, നീ എന്താ കാശ് അയക്കാത്തെ, അതൊരു മോശമല്ലേ എന്ന് ചോദിച്ചു. പിന്നെ അതൊരു ഫൈറ്റ് ആയി. ഒരു 2 ദിവസത്തേക്ക് ഭയങ്കര ഓക്വേർഡ് സിറ്റുവേഷൻ ആയിരുന്നു. ഞങ്ങൾക്ക് ഇങ്ങനെ നമ്മൾ നേരിട്ട് കണ്ട പോലും സംസാരിക്കില്ലാത്ത ഒരു, കാരണം നമ്മൾ ഫൈറ്റ് ചെയ്തു അതും കാശിന് വേണ്ടി. അങ്ങനെ ഒരു കോൺസെപ്റ്റ് നമ്മുടെ ഉള്ളിൽ ഇതിൽ വന്നു. ഇമോഷണലി നമുക്ക് എല്ലാവർക്കും ബാഡ് ആയിട്ട് ഫീൽ ചെയ്തു. ഒരു 2-3 days കഴിഞ്ഞപ്പോൾ എനിക്ക് തന്നെ തോന്നി, ഇങ്ങനെ സൈലന്റ് ആയിട്ട് പോയാൽ ശരിയാവില്ല, നമുക്ക് ഇതിനൊരു സൊല്യൂഷൻ വേണ്ടേ. ഞങ്ങൾ 3 പേരും ഇങ്ങനെ സംസാരിച്ചു, നമുക്ക് അവളോട് പോയി സംസാരിക്കാം. ഞങ്ങൾ നേരിട്ട് അവളോട് എന്നിട്ട് ചോദിച്ചു, ജസ്റ്റ് ഒറ്റൊരു ക്വസ്റ്റ്യൻ, അതാണ് ചേഞ്ച് ചെയ്തത്, എന്താണ് പറ്റിയത്, അല്ലെങ്കിൽ എന്തുകൊണ്ടാണ് നീ തരാത്തത്, എന്താണ് ബുദ്ധിമുട്ട്, അങ്ങനെ ഒരു കാര്യം ചോദിച്ചേ ഉള്ളൂ. അപ്പൊ തന്നെ അവള് കരഞ്ഞു. ആൻഡ് ഷീ ടെൽ ദാറ്റ് there was a lot of family problems and financial problems, like she was embarrassed to tell us, അല്ലെങ്കിൽ it was an awkward situation for her to tell us how we will face her or what we will think about her. അങ്ങനെയുള്ള ഒരു തോട്ട് ഉള്ളതിന്റെ ബേസിസിൽ she didn't tell us. പക്ഷെ അവൾ ആ ഒരു കാര്യം പറഞ്ഞപ്പോ എനിക്ക് ശരിക്കും, ഞാൻ ഇന്നും ഹോണസ്റ്റ്ലി ഒരു ഗിൽറ്റി ഫീൽ വരുന്നത്, നമ്മൾ ഒരു കാര്യം നോട്ട് ചെയ്ത് പറഞ്ഞു. നിങ്ങൾ അന്ന് ദേഷ്യപ്പെട്ടപ്പോ എന്നോട് ഒരു കാര്യം പറഞ്ഞു, എന്താന്ന് വെച്ചാൽ ദേഷ്യത്തിൽ വന്നിട്ട് എന്നെ ചീത്തയാണ് പറഞ്ഞത്, അതോ എനിക്ക് എന്താണ് പറ്റിയെന്ന് എന്നോട് ചോദിച്ചില്ല. എന്താണ് അവക്കടെ ഭാഗം എന്താണെന്ന് നിങ്ങൾ ആദ്യം ചോദിച്ചില്ല. അതാണ് എനിക്ക് ശരിക്കും, കാരണം എന്ന് വെച്ചാൽ നമ്മൾ അവളെ പ്രീജഡ്ജ് ചെയ്ത് പോയിട്ട് നേരെ ചെന്ന് ചോദിക്കുകയാണ് ചെയ്തത്. അല്ലാതെ അവളുടെ ഭാഗം കേട്ടിട്ട് അവക്ക് എന്താ പറ്റിയെന്ന ഒരു സൊല്യൂഷൻ അല്ല. നമ്മൾ നേരത്തെ പ്രീജഡ്ജ് ആയിട്ട് നമ്മുടെ ഭാഗം മാത്രം കേട്ട് നേരെ ചെന്ന് അറ്റാക്കിംഗ് ആണ് അവിടെ നടക്കുന്നത്, ഒരു ഫൈറ്റിംഗ്. അതാണ് ഫൈറ്റ് ക്രിയേറ്റ് ചെയ്യുന്നതിന്റെ മെയിൻ ഒരു പ്രോബ്ലം. ശരിക്കും ഇവിടെ നമുക്ക് മനസ്സിലാക്കാൻ പറ്റും, ഈ ഒരു സിറ്റുവേഷനിൽ നമ്മളെല്ലാവരും നമ്മുടെ പൊസിഷനാണ് നോക്കാം, പക്ഷെ നമ്മുടെ റിയൽ ഇൻട്രസ്റ്റ് എന്ന് പറഞ്ഞാൽ വേറെ ആയിരിക്കും. ഇപ്പൊ ഞാൻ എന്നെ പറയുകയാണെങ്കിൽ എനിക്ക് അവിടുത്തെ മെയിൻ ഇൻട്രസ്റ്റ് എന്ന് പറഞ്ഞാൽ എല്ലാവരും കാശ് ഒരുപോലെ, അവള് കാശ് തന്നിട്ടില്ല അന്നത്തെ ഡേറ്റിന്, പക്ഷെ എന്റെ റിയൽ ഇൻട്രസ്റ്റ് എന്ന് പറഞ്ഞാൽ എല്ലാവരും ഈക്വലി ഷെയർ ചെയ്യണം, അവക്കടെ ബേർഡനും കൂടി എനിക്ക് എടുക്കാൻ പറ്റില്ല. പക്ഷെ ഇപ്പോ എന്റെ ഫ്രണ്ട് റൂംമേറ്റ് കാശ് തരാത്ത കുട്ടിയുടെ ഒരു പൊസിഷൻ ആലോചിച്ച്, ഷീ ഡിഡിൻ പേ, പക്ഷെ അവളുടെ റിയൽ ഇൻട്രസ്റ്റ് എന്ന് പറയുമ്പോൾ എന്തായിരുന്നു, അവർക്ക് ജെന്യൂൻലി ആഗ്രഹം ഉണ്ടായിരുന്നു പേയ്മെന്റ് നടത്തണമെന്ന്, പക്ഷെ പേയ്മെന്റ് ചെയ്യാൻ പറ്റാത്തത് സിറ്റുവേഷൻ ബേസിസിലായിരുന്നു, കാരണം സിറ്റുവേഷൻ സമ്മതിക്കില്ലാത്തൊരവസ്ഥ. ഇവിടെ നമ്മള് അങ്ങോട്ടും ഇങ്ങോട്ടും നമ്മളൊരു സമാധാനപരമായിട്ട് സംസാരിച്ചപ്പോ എന്താ സംഭവിച്ചതെന്ന് വെച്ചാൽ, നമ്മള് മനസ്സിലായി, ഞങ്ങളുടെ ഭാഗത്തു നിന്നുള്ള തെറ്റും അവക്ക് പറയാനുള്ള ഒരു ബുദ്ധിമുട്ടും ഉണ്ടായിരുന്നു, അല്ലെങ്കിൽ ഒരു കമ്മ്യൂണിക്കേഷൻ ബാരിയർ അവിടെ ഉണ്ടായിരുന്നു എന്ന് ഞങ്ങൾക്ക് മനസ്സിലായി. ആ ബാരിയർ നമ്മൾ കമ്മ്യൂണിക്കേറ്റ് ചെയ്തു, ജസ്റ്റ് വി ലിസൺ ടു ഹർ. അപ്പൊ കമ്മ്യൂണിക്കേഷൻ ബാരിയർ ബ്രോക്ക് ചെയ്യാണ് ചെയ്തത്. അപ്പൊ തന്നെ ഞങ്ങളുടെ ഒരു ഓക്വേർഡ്നെസ്, അല്ലെങ്കിൽ നമുക്കൊരു ഫ്ലോ, ഒരു കമ്മ്യൂണിക്കേഷൻ ഫ്ലോ വരെ അവിടെ ക്രിയേറ്റ് ചെയ്യാൻ പറ്റി. ഞങ്ങൾ അങ്ങനെ ഇരുന്ന് തന്നെ അവക്ക്, ഇപ്പൊ നമ്മുടെ പ്രശ്നം എന്താ, നമുക്ക് ഇനിയും മുന്നോട്ട് അവക്ക് ക്യാഷ് നമ്മുടെ അടുത്ത് തരണം, അല്ലാതെ നമുക്ക് മുന്നോട്ട് എത്ര നാൾ നമ്മൾ അവർക്ക് കവർ ചെയ്യും. ഞങ്ങൾ അവർക്ക് പലതരത്തിലുള്ള സൊല്യൂഷൻസ്, കാരണം അവൾ നമ്മളോട് കമ്മ്യൂണിക്കേറ്റ് ചെയ്യാത്തത് കൊണ്ടാണ് നമുക്ക് സൊല്യൂഷൻസ് പറഞ്ഞു കൊടുക്കാൻ പറ്റാതിരുന്നത്. കമ്മ്യൂണിക്കേറ്റ് ചെയ്തപ്പോൾ ഞങ്ങൾ പല ഐഡിയാസ് പറഞ്ഞു കൊടുത്തു, നമുക്ക് എങ്ങനെ ഇനി ഫാമിലി പ്രോബ്ലംസ് ഉണ്ട് അത് ഓക്കെ, പക്ഷെ എങ്ങനെ നമുക്ക് അത് കോപ്പപ്പ് ചെയ്ത് പോകാൻ പറ്റുമെന്നുള്ള ഒരു സൊല്യൂഷൻസ് ഞങ്ങൾ ഐഡിയാസ് പറഞ്ഞു കൊടുക്കുകയാണ് ചെയ്തത്. ഈ ഒരു എക്സ്പീരിയൻസിന് ആക്ച്വലി എനിക്ക് മനസ്സിലായെന്ന് വെച്ചാൽ, നമ്മുടെ ജീവിതത്തിൽ പലതരത്തിൽ, ചിലപ്പോൾ വെറുതെ ആയിരിക്കും, ചിലത് ചെറുതായിരിക്കാം, ചിലപ്പോൾ വലുതായിരിക്കാം, പലതരത്തിൽ കോൺഫ്ലിക്ട്സ് ഉണ്ട്. ശരിക്കും ഈ കോൺഫ്ലിക്ട്സ് എന്ന് പറഞ്ഞ ഒരു സംഭവം, അതൊരു ഗസ്റ്റാ ഡെയിലി ലൈഫിൽ, നമ്മുടെ ഡെയിലി ലൈഫിൽ ഒരു ഗസ്റ്റ് ആയിട്ട് സ്ഥിരം വന്നു പോയിക്കൊണ്ടേയിരിക്കും. നമുക്ക് ഒരിക്കലും അതിനെ തടുക്കാൻ പറ്റില്ല. അപ്പൊ ഇങ്ങനെ ഗസ്റ്റ് ആയിട്ട് വരുന്ന ആളെ നമ്മൾ എങ്ങനെ ഹാൻഡിൽ ചെയ്യുന്നതിലായിരിക്കും മെയിൻലി നമ്മുടെ റിലേഷൻഷിപ്സ് നമ്മൾ എങ്ങനെ പ്രിസർവ് ചെയ്യുന്നു, അല്ലെങ്കിൽ അത് നമ്മൾ എങ്ങനെ ബ്രേക്ക് ചെയ്യുന്നു, ഡിപ്പെൻഡ്സ് അപ്പോൺ ഹൗ വി ഹാൻഡിൽ ഇറ്റ് ഓൾ. അല്ലാതെ നമ്മളത് ബ്രേക്ക് ചെയ്യുന്നത് മറ്റൊരാളുടെ ഭാഗത്തേട്ട് അതിന്റെ ബേർഡൻ ഇടാതെ ജസ്റ്റ് വി ലിസൺ. നമ്മൾ ആദ്യം അത് ലിസൺ ചെയ്ത് അതിനെങ്ങനെ കാംലി സ്മൂത്ത്ലി ഇമോഷണലി ഹാൻഡിൽ ചെയ്ത് എങ്ങനെ ഒരു ബെസ്റ്റ് സൊല്യൂഷൻ, ഇപ്പോ ഒരു നമ്മുടെ ഇൻട്രസ്റ്റ് ബേസിസിൽ നമ്മൾ ഇങ്ങനെ ഒരു സൊല്യൂഷൻ കണ്ടെത്തി വരും, അല്ലെങ്കിൽ ഒരു ബെസ്റ്റ് സൊല്യൂഷൻ ഫോർ ബോത്ത് സൈഡ്സ് എങ്ങനെ അറ്റൈൻ ചെയ്യുന്നു, അതിലാണ് നമ്മൾ എങ്ങനെ നമ്മുടെ ഒരു റിലേഷൻഷിപ്പ് അല്ലെങ്കിൽ ഒരു ഫാമിലി അല്ലെങ്കിൽ ഒരു വർക്ക് പ്ലേസ് കമ്മ്യൂണിറ്റി അല്ലെങ്കിൽ നമ്മുടെ ഒരു സൊസൈറ്റിയിലെ ഏതൊരു പ്രോബ്ലം ആയിക്കോട്ടെ, നമ്മൾ ഇങ്ങനെയാണ് നമ്മൾ ഒരു പ്രോബ്ലം അല്ലെങ്കിൽ ഒരു കോൺഫ്ലിക്റ്റ് നമ്മൾ സോൾവ് ചെയ്യുന്നത്. ഈ ഒരു എക്സ്പീരിയൻസിൽ നിന്ന് മനസ്സിലാക്കിയതെന്ന് വെച്ചാൽ മീഡിയേഷന്റെ ഈ സ്കിൽസ് എല്ലാം ഞാൻ ഇവിടെ അപ്ലൈ ചെയ്യുന്നുണ്ട്. കാരണം ഞാൻ ലിസണിങ് ചെയ്യുന്നുണ്ട്, പിന്നെ ഒരു അവരുടെ ഇൻട്രസ്റ്റ് ഫൈൻഡിങ് ഔട്ട് ദർ അതർ പേഴ്സൺ ഇൻട്രസ്റ്റ് ആൻഡ് വി ആർ നാവിഗേറ്റിംഗ് എ ബെറ്റർ സൊല്യൂഷൻ ഫോർ ഓൾസോ ഹിയർ. ഇത്രയത്തിൽ നിന്ന് എനിക്ക് മനസ്സിലായ മീഡിയേഷൻ സ്കിൽ ഡസ് give not just a better professional or a better lawyer, it also makes us a better person who can handle the relationship in better way. അതാണ് എനിക്ക് എന്റെ പേഴ്സണൽ എക്സ്പീരിയൻസ് ഐ തിങ്ക് ടു ഷെയർ.
Thank you, Munira, and I think that is definitely a different way of looking at it. We look at mediation from a very professional point of view, but we forget some of the fundamentals, and this is why I think Aditya said mediation is one of the most natural choices. Nobody told you, to mediate the matter or negotiate the matter. It was very natural to you. So I think one of the reasons why mediation is here to stay is because it is very fundamental to us. One of the most natural ways we resolve disputes is through mediation or negotiation. And Munira giving that particular personal touch to it. And we are glad that the mediation masterclass helped you to become a better person and a very effective colleague, at least for your friends. Now, I think those are the main points we wanted to talk about, that mediation is coming to the fore. If I were to summarize what I just mentioned is, one, mediation is coming to the fore. You can't deny it. Developments are happening all across the globe. Developments are definitely happening in India. Now, there are many reasons why that's happening. Munira is what she said is a typical example why it is happening, why mediation is becoming to the fore. Lawyers, all these happenings, all these developments, all these mediation act, mediation practices, mediation centers are giving us lawyers a lot of opportunities. Overwhelming opportunities, if I would say. I told you that there is a lot of money to be won in the mediation market, and the mediation market is still growing. There are many ways of getting that money. I said you can take specialized jobs, you can become a better lawyer, you can become a better professional. And you can, by the way, you can also become a better or more effective person. So this is the message, and that is one of the reasons why I think we are pushing this particular topic, that as a lawyer, learning mediation helps you. One of the things which we want to highlight further is mediation advocacy. People have now starting to hear about mediation advocacy, but nobody understands the real scope of mediation advocacy. We are going to deal with that in a similar format, a conversational, in the next session, which happens on the 21st of July. For now, we are going to take questions. And I know that some of the lawyers, and I had a conversation with Sarai before, and people are concerned, what happens to their short-term prospects as a lawyer in terms of money when you indulge in mediation? There are many questions related to mediation. Sarai, do you want to raise some of those?
Yes, good evening, everybody. It is fundamentally not questions that I have concerns on, but when I speak about mediation to colleagues, to advocates in the profession, and I recommend that instead of, in most of their cases also, when I hear someone's story or a situation in a court and I say, why don't you try to mediate on this? Advocates generally come up saying that mediation doesn't fill the wallet, doesn't secure your future, is not a great idea. And the fear is often that you will lose out when the others are making the money if you go into mediation rather than litigation. And therefore, what I have seen from my friends' practice, I was away for 15 years, and that time And after I came back, what I found is people see this as a great financial disincentive going into mediation. But that is not the truth, is what I see. And they also are trained in this adversarial professional culture, because of which they have a concern about the mediation process itself, saying, we have been taught to fight, so why would we then want to settle with someone? We should be arguing the matter in the court and resolving it there. That is the training part of what we have all gone through. I too have gone through that, but probably because when I was in the government working, we also, although I was a legal officer, I also used to have to interact a lot with interpersonal matters in HR or industrial disputes. And most of the organizations where I worked, the first one was 23,000 employees. The second was almost 12,000 regular employees and about 20,000 of contract employees. So that's huge numbers. The least I worked with was with just about 1,000 employees in Kochi. All the rest was huge numbers. And so resolving issues at the start of an issue was always more important, and which is why I probably always advocate that let's sit the people across the table and see if we can solve the matter rather than going for a court. So one of the most cited reasons for reluctance is a financial impact on advocates, especially in places like the where you bill by the hour. Our profession is known to be something that bills by the hour. And if we were to go for a litigation, it would be pre-trial and then trial, lengthy procedures, discovery, this. So it gives you more hours, and so you bill people more. So on an average, people make more money if you have longer. Whereas in mediation, the number of hours you can bill is cut down drastically. It is a fact that we are able to give a quick solution, or at least assist in probably arriving at a quicker solution for our client. But we have been trained to think of our bills as well, and therefore we have the economic interest is not aligning with the client's interest of quicker solutions. So that is one real concern I have seen from people. The other, like I said, because we've been trained in the adversarial culture, to change oneself and to bring to propose to your client or to the opposite party, to propose to your client, then the client has you have the feeling that, will the client think that I'm an incapable lawyer? Will the client think that we have a bad case? Those are some sides on some matters on your own side, and the opposite party thinking, oh, I have a better case, and that is why they're coming down on their knees, which is not the fact. It is just that we're saving time and effort, both for all parties, and like Kenneth said, a win-win for everybody. But people don't see it in that manner. The advocates don't see it in that manner. So a requirement of a mindset change is very important, is what I feel. Because like in the Mahabharata, I will not give an inch of land in Hastinapura. Similar situation, I will not give an inch of property here or anything here. I will not give an inch in the case, is the attitude we have. And also what I have felt is lawyers, we guide the client through to the judgment. We guide the client through to which forum he has to go to. We guide the client with the case and the strategy. All that is lost. Our control is lost completely if we are going for a mediation, is what we presume, which is not the truth, but that's what we presume, lawyers. We presume that when there is party autonomy and the party is there sitting along with you in the mediation, and he sees that this is a very informal kind of thing which he himself can handle, would I lose my job? That's one way of looking at it. But again, although it empowers the parties are not necessarily always as savvy as the one who came to Aditya, for example, who already knew what he had to do, or what his goals were very clear, and he knew the end result he wanted, and he was not willing to go in for anything other than mediation. So that the party is aware, but the lawyer is fearing that he might lose control. It is not true. When I speak to any of my clients, people who come with cases, and some people tell me, recently I was at a meeting of distributors. I was called to speak on some matter. And one of the speakers, who is also an income tax advisory member, said in the meeting that the first person you should appoint in your business is an accountant, a good accountant. I was an ex-speaker. I told him, no, before that, you have to appoint a good lawyer. Because whatever contract you're going to enter into, you just sign on it without reading, understanding the implications, whereas a lawyer will be able to advise you on what those things are. So first you appoint a good advocate. And it's the same thing with the mediation. You appoint a good advocate who will see you through, whether you are on the plaintiff side, you're the prosecutor, or you're on the defendant side, defending a case against you. If the lawyer is good, and he is ready to sail with you, he is ready to take care of your interest and see that you get a faster solution, definitely that helps. Now, I have found that lawyers also have a fear about the quality of mediations, because at some point people think that anybody can be a mediator, and therefore, will I get justice? Will the person understand the situation? It's not as if for example, like in arbitrations also, we have judges, or the tribunal need not always consist of judges and advocates. It can even be an engineer, for example. If the matter is an expertise somewhere, you need an expertise like that, that kind of a person comes in. So the lawyers have a feeling that will the mediator give this efficient answer? The client has a feeling, will the mediator give a efficient answer? But the fact is, it's not they who are deciding. It is a party who is deciding himself. Both the parties are sitting across and deciding what is best for them. We are only just helping them in arriving at that solution. And so the quality is not going to go bad. But at the same time, when you look at, like earlier we said about the commercial courts matter where pre-litigation mediation is mandatory. Similarly, we have in the family court matters, it is essential that you go through the mediation process because there is power imbalance. One side has got more say, power, money, whatever, and the other side may not. So a mediation is definitely going to help in the process. And it is not really a waste of money, which is what people think. Mediation is a waste of time and money, which is not. It gives you a solution where both, like you said, the relationship is maintained, both parties enjoy the benefit, and everybody goes happy. But people have to come forward for it. Lawyers have to come forward for it. I have found personally in my practice, which I've now restarted over the last close to 9.5 years, that because I advocate a lot of mediation, even before I came to the Mediation Society, but because I advocate mediation, I say, why don't I speak on your behalf to the opposite side, and then we'll see if we can sit at the table. I say that almost to every one of my clients. I have not lost a single client. On the contrary, I have always seen that the client to whom I have given such a suggestion brings in at least 2 other clients for me. I get more and more cases. I'm not losing out at all. And because we are able to settle those cases faster, I may be getting lesser in terms of hours, money, etc. But the number of cases is just growing. I can't handle them. That's the situation. So that's a fact. And so I think there should not be a fear in going into mediation. It is not, you're not treading into a place where angels fear to tread. It is not like that. It is the best place to be in. It is probably the way forward for the country as a whole, which is probably why everybody, the Chief Justices, the legislature, everybody's realized it and bringing in the act. So I think we are in the right direction.
Thank you, Sarah. I think excellent points, and I think you hit the nail on its head by saying that yes, potentially there may be a short-term income drop potentially, but that is made up with the long-term connection with the parties, professional engagement parties, and long-term benefits in terms of real money and income. So that is well compensated. And there is another side to it. If you don't recommend mediation deliberately to win more money, the chances of you losing out the client or the client thinking that you are a greedy lawyer who wants to make money out of him at his cost is much higher. So there is that danger as well. One is the positive side of getting more and more clients and having a relationship even with the clients, so that more professional engagements are coming your way. You also risk losing clients when you don't advise them appropriately, if in case mediation is the appropriate choice. Interesting, very interesting. And we can take more questions if there are any questions.
We have a few questions in the chat, so I'll just read it out. One question asks, how can law students get mediation training?
Mediation masterclass by the Mediation Society. Thank you for that self-serving question. We periodically, very frequently, announce mediation masterclasses, usually at a nominal fee or no fee. We also work with law schools to have customized masterclasses for them. So when we announce that, please let us know, please register, and we will see whether it's appropriate course for you. And if it is an appropriate course, we will let you in. Best way. Of course, there are other private training programs going on. I'm not going to advertise any of them, but there may be other training programs involved as well. But this is definitely one way of getting trained.
Shravya, we hope that we have answered your concern. So please get in touch with the Mediation Society. We have our WhatsApp group, so we'll just share that link in the chat so that you can stay connected with us for all our future updates. The next question is, who is better, a mediator or a mediation advocate?
Well, that's a tough one. I mean, actually, there is no answer to that. As I said, mediation is about facilitated negotiation. You negotiate. You can't have a mediation without any of this. If you don't negotiate, there is no mediation. If you don't facilitate that negotiation, there is no mediation. So the point is, both are equally important for mediation. So you need to have a negotiation happening, and that negotiation is conducted by mediation advocates. You need that to be facilitated properly, and that is done by the mediator. So if you ask me which one is more important, I don't think there is an answer, and there should not be an answer. Both are equally relevant. But which one should you, as a lawyer, take up? That's a different question. Say, for example, you are a junior lawyer, and this is a question we often get. If you are a junior lawyer and you like mediation, for whatever, Munira is in love with mediation after her personal experience, and many of you responded to that particular story. So you like mediation, you are starting to practice, and when you start to practice, who should I be aiming for, becoming a mediator or mediation advocate? My answer is very, very clear. Become a mediation advocate. Many reasons for that. One, to become a mediator, the entry bar is slightly high. If you want to go into court-annexed mediation, which is the only type of mediation which is commonly available in Kerala, at least for the time being, it's going to change soon. But for now, to be a court-annexed mediator, you need 15 years practice. And then, of course, you have to be selected and you have to go through a particular course. That is a huge barrier for junior entry-level lawyers. So, but you still can be a mediator if you're invited to. You don't need any particular qualifications. Another difficulty with becoming a mediator is, once you become a mediator, because of the conflict of interest and confidentiality requirements, once you act in a mediation between two parties, you may not be able to represent each of the parties. You may not be able to act as a counsel for any of the parties. You cannot appear for them in an arbitration. So you actually conflict them out, meaning that for a fee which you gain as a mediator, you may be losing out on a lot of fees as a mediation advocate. So those are the two things which I think puts you, which is the reason why I think becoming a mediator should not be the immediate aim of a lawyer. But becoming a mediation advocate should be the aim of a lawyer. The reason is this: you can take that along with your practice smoothly without any hindrance. You're basically representing your client. Just as you do in the courtroom, you are representing your client in the boardroom where the mediator is. In the mediation room, you are negotiating for your client. You are drafting for your client. You are advising your client. You are helping the client to enforce an immediate settlement agreement in the court. All of these things you do as a lawyer or you are doing for your client. So becoming a mediation advocate is a very smooth transition for you. The only thing I think you are less familiar with will be the negotiation bit. You're not very much, I know that negotiation is part of your curriculum in LLB, but for the junior lawyers, you don't usually get trained in negotiation as much as you get trained in litigation. That should change, and that is changing, and that will change eventually. But answering your question, if you are a junior lawyer, 1 to 5 years, don't try to become a mediator. Okay, if it comes your way, take it. But otherwise, try to earnestly seek to become a mediation advocate, which will be very rewarding. And there is no hindrances, no obstacles in becoming a mediation advocate while you continue with your practice. And that is why in the next session, we will be dealing with mediation advocacy as a perfect addition to your legal practice.
I think we'll take up one more question. There is one question from Diane Lal. She asks, is there something called as online mediation? Can a mediator do online mediation with the consent of parties?
Oh, yes, that is the trend. Online, they do it in many ways. I mean, it's not purely always on the Zoom, people talk. You can have a hybrid where you can meet online, you can exchange emails, contracts online, you can even sign electronically, but you can meet in part. So a lot of things can happen. You can use technology into mediation. You can bring technology into mediation, and you may want to know that Mediation Act 2023 specifically says they want to recognize online mediations because they see that's the future of mediation. So yes, online mediations are allowed. Online mediations are almost a trend. There are many mediation centers which are providing softwares which allows you to have a confidential dialogue and communication. So online things, but of course it comes with its own challenges. Sometimes people are conditioned, at least my generation or the current generation is conditioned to meet personally to resolve issues. Sometimes they prefer, rather than talking over the Zoom, they prefer to talk in person. Sometimes some of the emotions, vending of those emotions, they may want to happen in person. So some of the challenges have not gone away, but the advantages of having to, like the sessions we are having now, you can be anywhere, at home, at work, or anywhere in India or abroad, still listen to us. So all these benefits applies to mediation as well. Of course, the technology has developed to an extent where you can have it confidential and intact. So online is very much on board.
Yes, thank you, Advocate Rajesh. Due to time constraints, we won't be able to take up further questions for today's session, but we look forward to welcoming you all to our part 2, which will be on the 21st of July on the topic where we will discuss mediation advocacy, a strategic addition to your legal practice. As we conclude today's session, I extend my sincere thanks to all the participants and to all our speakers for joining us this evening. Let me conclude with the essence of this session. The real question is, therefore, no longer whether mediation is worth learning, but how you choose to engage with it in your practice, how you serve your clients, and how you build your professional future. Thank you, everyone, for joining us. Have a very good night.
Thank you.